Hello, I'm Robert Bateman, and this is the Privacy Corner, where I talk you through my top 3 picks for privacy developments each week. And thank you, as always, to Privado AI for sponsoring the show. So this week, there's a new data broker law in the US that aims to protect personal data from foreign adversaries. Will it work? Let's have a look. The EDPB has released its 2024 to 27 strategy. There's not that much in it, but I've found what's of value, so I'll share that with you. And the ICO has lost its appeal against Experian. So we'll look at what went wrong for the UK's Data Protection Authority. So first of all, the US privacy bill I mentioned. This is not the bill that requires TikTok to divest from ByteDance. That's a separate part of the same sort of omnibus package. This is the Protecting Americans' Data from Foreign Adversaries Act of 2024, and it starts out quite reasonably. There's a prohibition. It's about 48 words in total. It shall be unlawful for a data broker to sell, etc., or make available personally identifiable sensitive data of a United States individual to any foreign adversary country or any entity that is controlled by a foreign adversary. Sounds reasonable, but the devil's in the detail. So first of all, the term data broker is also quite broad and fairly sensible. An entity that, for valuable consideration, so that's basically any benefit to which it's not legally entitled, could be money, could be something else, makes available the data of United States individuals that the entity did not collect directly from the individuals to another entity that is not acting as a service provider. The law then provides a list of things that are not data broker activities, and they're all fairly sensible too. Things about reporting or publishing news, disseminating information, and doesn't include pornography, but it also includes the service provider exclusion. So disclosing data to an entity that is acting as a service provider does not count. Of course, people will quiver over whether that distracts any sort of power from the law, but it's always good to have something about service providers in there, I think. Then we come to the sensitive data definition. So first of all, this is personally identifiable sensitive data. So it's got to be linked or reasonably linkable, etc. And then there's a whole long list of types of sensitive data, as you expect from US laws. More so in the past. We are moving away from that a bit, but this law retains it. And it's a very long list. So government issued identifiers are there, of course, health data, financial data, biometrics, genetics. I mean, it goes A to Q. It's so long and yet so particular. I wonder really whether it was worth making this list, whether a more sensible approach, a more elegant approach might be to just define sensitive data as a concept and then apply a kind of risk analysis as to whether it's disclosable. But that's kind of the European way of doing things. In the US, the laws still have a lot of lists. The covered nations, or the foreign adversaries, come from another law. At present, they are North Korea, China, Russia and Iran. Those are subject to change at, I am told, quite short notice. And you can also be controlled by a foreign adversary if you are domiciled there, have your headquarters there, do most of your business there, or directly, or if a foreign government, you know, from one of these 4 countries owns at least 20% of your company. So this is another American federal privacy law of some sort, and of course it's moving towards tighter control over what people do with data, but it still kind of whittles itself away through exemptions and exclusions, and we're left with not that much in the end. So the EDPB has released a strategy document outlining its approach for 2024 to 27. So what are they up to over the next 3 years? Well, they didn't have too much to say here. They did use quite a lot of words to say it, but there isn't really that much substance in it. I did gather that we can expect guidance in a few interesting areas. Legitimate interests, so I'll be very interested to read what the EDPB has to say about those, because we know that the board is notoriously strict in its interpretations of GDPR provisions, so that could be quite controversial. Data subjects, vulnerable data subjects such as children, certifications and codes of conduct, we can expect a bit of guidance, and also non-expert guidance, so directed towards children and SMEs. It will be interesting to see how the EDPB tempers and simplifies its language for those audiences. The board also says it will continue to work with its support pool of experts. I have heard that they are not frequently drawn upon, at least those of the pool that I know, and the coordinated enforcement network. And get this, it will reiterate its commitment to the smooth functioning of the one-stop shop. Now, I was a bit disparaging about the EDPB's remark here, but they aren't necessarily technically saying that the one-stop shop does function smoothly, because it plainly doesn't. They are just saying that they will reiterate their commitment to it functioning smoothly. There'll also be guidance, it seems, on how the GDPR and other laws interact. So they name check the AI Act and the Digital Services Package, so it could be the DSA or the DMA, and they might adopt binding decisions in the context of the Data Act. I confess, I did not know that they could do that. So where personal data is concerned, they can adopt Data Act binding decisions. I'd be very interested to see how that works in practice. So overall, the only sectors that get a real mention here are AI and digital identity services. They don't say they're going to enforce against companies in those sectors, but they do say they'll be monitoring and assessing developments in those areas. So perhaps that's a bit of a warning sign for players in those particular markets. But other than that, we can look forward to some guidance on legitimate interests. That was a highlight to me. So lastly, the ICO, the UK's regulator, has lost another appeal to Experian Limited. This is at the UK's upper tribunal. The first tier tribunal case came out last year, and the ICO lost that and appealed. Experian, you may or may not know, is effectively a data broker. And if you live in the UK, they almost certainly have a file on you, and it contains up to 400 data points about who you might be, what sorts of things you might like to buy, how many children you might have, etc. I've seen mine, and it is grossly inaccurate. It really is not very good. Anyone directing their postal marketing on the basis of that particular record is not going to have very much luck reaching the right sorts of people. That's not to say other people's records aren't entirely accurate, of course. And the ICO was not too happy with how Experian was going about building this database. So in 2020, it sent Experian an enforcement notice, ordering it to do a number of things, mostly around updating its privacy notices, stop processing personal data collected by third parties on the basis of consent under the basis of Experian's legitimate interests, stop using data gleaned from its credit reference agency, its main business, for direct marketing purposes, and stop directly directly provide data subjects with an Article 14 compliant privacy notice where their data have been acquired from third parties or publicly available sources. Quite a few other bits, no fine as far as I recall, but the first tier tribunal, well, sided with Experian on pretty much every matter. So the ICO was told that its enforcement notice was unreasonable, that it would impose a huge cost on Experian, who basically said this would cause our marketing wing to go out of business. And Experian were ordered by a replacement, a supplemental, substitute enforcement notice from the first tier tribunal to just send out some Article 14 notices to certain sorts of data subjects whose data had been derived from publicly available sources, because they had not had anything from Experian previously. So one problem at the first tier tribunal was the expert witness called upon by the ICO, who actually works for the ICO as well, who later accepted that his evidence had been completely wrong, completely misleading and perverse. These are not words you want associated with your expert witness's testimony. So the first tier tribunal seemed to conclude, and the upper tribunal also concluded, led the ICO to misunderstand the nature of Experian's processing, the kinds of harms it might provoke, and the kinds of risks it represented. So there was a long bit about the ICO wanting Experian to redo its legitimate interest assessments, and the upper tribunal kind of said, well, you shouldn't really be doing that because you don't even understand, you've misunderstood the nature of Experian's activities, and there isn't really any risk here. The upper tribunal totally dismissed the ICO's case. It was not a good day for the ICO. They, in places, did accept that the first tier tribunal had misunderstood certain things about the GDPR, but that in the end it had applied them correctly anyway, so it didn't really matter. They had to infer a lot of things about what the justices at the first tier tribunal might have been thinking, and it did not go in the ICO's favour. You can read this judgment. It's incredibly boring. I mean, it really is very dull. But if you want to understand a bit more about the UK system, then it's quite helpful for setting out some sort of legal principles and whatnot. Well, that's all from me this week. Thank you so much for your time and attention. Thank you again to Privado AI, and I'll see you next week.